Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Ms. Williamson. Good morning.
Morning.
Morning. Good morning.
We are here today to do a couple of arguments, we're going to have two arguments today. You are frequent arguers in our court. We're trying to cut down having as many oral arguments. So we're trying for 3 a day, having as long oral arguments, as many in one day, instead of having 5 or 6 and killing ourselves. But what happened, we had 3 set for today. Well, one of them involved San Antonio attorneys. They were completely out of their office. I don't even know if they're back in yet still because of the weather last week. So we're down to 2. And so with that, we'll call our first case this morning, 11-19-325 CR. Is it Schibi?
Or Schibi, I believe, Your Honor.
Schibi. Okay. Schibi versus State of Texas. Mr. Rice, are you ready to proceed?
Ready, Your Honor.
You know, Mr. Rice, I'll tell you, it's hard to hear you.
The risk of scaring the court, I'll move closer to the...
That's much better.
Thank you, Your Honor. May it please the court and counsel. Mike Schibi was convicted of a crime for which he was never charged. I don't believe there's any dispute as to the underlying facts here. Briefly, he was charged with pulling a knife on his father. The information alleged that he was charged by information, and it alleged that he had pulled a knife on his father and threatened him. Mr. Schibi goes to court to enter into a plea agreement. He signs a stipulation of evidence, which tracks the language in the information. He waives the indictment, tracks the language in the information, which says that he's threatened his father with a knife and aggravated assault under Penal Code Section 22.02B. When he gets to court, he's told this is a first-degree felony, and he's admonished that the range of punishment is 5 to 99. In order for this to have been a first-degree felony under 22.02B1, we needed the element of serious bodily injury to the victim. And that was not present in this case. Nonetheless,
Counsel?
Yes, sir.
Was he convicted of second degree?
No, Your Honor. He was convicted of first degree felony 22.02B1. That's reflected in the judgment on the deferred adjudication and on the final judgment as well. He enters into the plea agreement for probation for deferred. A few years later, that is revoked, and he's found guilty. And I note that he pleads guilty as charged, and he's found guilty as charged. But again, the charge does not make any reference to any serious bodily injury. And the record is before the court that shows that there was no testimony on the plea papers before the court. The stipulation of evidence is before the court. There's no allegations or any evidence of any kind of any serious bodily injury to anyone. Therefore, we have a problem. We have a mistake made by the parties here.
So the charging instrument has no allegation of serious bodily injury?
Correct, Your Honor, it does not. So what happened was just that there was a mistake that the district attorney, the defense counsel, and the trial judge all seemed to have missed, that there was no serious bodily injury here. Yet he was still convicted of a first degree felony under 22.02B1. So now what do we do at this point? How do we correct this error? And tip of my hat to opposing counsel, because I believe he framed this issue in a much better manner than I did. And the question we have here is whether or not this is a void judgment. Now, this court in 2018 addressed a similar situation in the Garcia case, which I added as a supplement to my index of authorities. In Garcia, the defendant in Brown County was in possession, a state jail felony possession amount of drugs. He was enhanced mistakenly, a mistaken enhancement of being in a drug-free zone when in fact he was not. Garcia was placed on probation. That probation was later revoked. And I guess at some point subsequent to that, they realized that the enhancement had been improper. The difference between that case and this case, however, is that the sentence he received was clearly in excess of that for a state jail felony. But that's not the case we have here. But I cite the Garcia case because this court lays out the parameters for an analysis of a void judgment. So the void judgment, the categories that we believe are relevant here that apply and make this judgment void, I think we have three. The first, as this court cites, is that the trial court had no jurisdiction. Now, the state says the court had jurisdiction because it's a district court and they have jurisdiction over first and second degree felonies. However, and I do apologize for the late entry of this authority, but there is a case in Dallas called Hall versus State, which is at 81 Southwest 3rd, 927. And it cites a 14th court decision in McLeod, but it says this, that a trial court has jurisdiction to convict a defendant of an offense not charged in an indictment only when that offense is a lesser included offense of the crime charged. In the Hall case, the defendant Hall was charged with murder, but the parties mistakenly added in the jury charge the option of aggravated assault. Aggravated assault not being a lesser included, the court was without jurisdiction to convict him of aggravated assault, which he was convicted of aggravated assault. But this court said that the trial court did not have jurisdiction for that purpose, and therefore the judgment was void. The second point that we believe makes this judgment void in this case is the evidentiary issue. Now that I have to admit that I have found scant case law on this type of situation, and I haven't found anything that mirrors exactly what we have here. But I believe these are all instructive. There's no evidence of any kind that, as I said earlier, that the missing element of serious bodily injury is present. It's not here. And in order to get to the first degree felony, you had to have serious bodily injury, which the state is required to prove beyond a reasonable doubt. According to Apprendi versus New Jersey, any element or any fact that enhances punishment must be established beyond a reasonable doubt. And then the third aspect is whether or not this was an illegal sentence. I haven't found anything that really clarifies the difference between or defines for this purpose a sentence, an illegal sentence. If the sentence is merely time, then what Schibi was given of 8 years falls within the punishment range for a first and second degree. But if the sentence includes not only the time involved, but the type of conviction, like a first degree felony, then this is also an illegal sentence. Now, this court in Garcia also added a harm analysis. I've seen some mixed reviews on whether or not a harm analysis in a void judgment is necessary or not. I'm going to just proceed and discuss it briefly because this court in Garcia states that a defendant establishes harm when he can show by a preponderance of the evidence that the error contributed to his conviction or punishment. Clearly here, the error is shown to contribute to his conviction. His conviction of a first-degree felony is based upon a mistake made by the parties. There's an error here. Now, the state has tried to couch this in terms of voluntariness. That this issue is really a voluntariness issue, and this is not the proper vehicle to challenge that. I would disagree with my colleague on that point. This is not really voluntariness. We're not really raising that issue here because he voluntarily admitted and pled guilty to the second degree. He never voluntarily pled to the first degree, but he did voluntarily plead to the second degree. Pled as charged. And I think that's kind of our operative term here is he pled as charged, and he was always charged with a second degree, not a first degree. So judgment's void. He is harmed because it did contribute to his conviction of first degree. Where do we go from here? And as this court pointed out in Garcia, or at least in Garcia, the plea agreement was being unenforceable because the enhancements were improper. Similarly here, the plea agreement is unenforceable, and the parties, as according to this court in Garcia, should be returned to their original position. And that's what we're asking, that this case be vacated and remanded and the parties be put in their original position. And I would add one more thing, although it's not really under the harm analysis in Garcia, this court did point out that if you don't know the proper range of punishment, that affects the plea agreement by both the state and the defendant. And in this case, if the defendant believes he's looking at 5 to 99, that's a big risk and a different risk than a 2 to 20. So there's no way of knowing, as this court said, there's no way of knowing what he would he have gone to trial, would he not have, had he been admonished the proper range of punishment, or would the state have offered a different, given him a different plea offer, had the state known that they didn't have the big stick of 5 to 99. And for those reasons, we'd ask that the case be vacated. And I would add one more thing, that in the void judgment analysis, we are required to look at the record to see if there's anything in the record that would cure this problem. And typically in the case law where someone has been improperly enhanced in punishment, if the record reflects another conviction that would work just as well to enhance the conviction, then there's no harm. But in this case, there's nothing in the record that shows that that would justify a first-degree felony. And with that, we'd ask that the court vacate this judgment and remand this case back to the trial court.
Mr. Rice, I have one quick question. What effect does the waiver of appeal in the first proceeding, I think it was in 13, and the fact that it was a plea bargain, and so you don't have a certification of a right to appeal from anything that happened in 13?
Your Honor, I believe, I believe it's the Nix case. If you give me 1 second here, which allows you, says that a void judgment is a nullity and can be attacked at any time. And I believe that is also the approach that this court took in Garcia. So
Garcia, it was a void judgment because the sentence imposed exceeded the range of punishment for the offense that he should have been convicted of.
Right. Yes, sir.
Okay.
But I believe if the question is, can we attack it now? I think a collateral attack, a void judgment is an exception to the rule of a prohibition on collateral attacks. But as I read what I've read and void sentence, and I quoting from Rich, who says, there has never been anything in Texas law that prevented any court with jurisdiction over a criminal case from noticing and correcting an illegal sentence, no matter how or when the relief was sought. And if an illegal sentence is a subset of a void judgment, I believe that's where we are.
All right. Thank you very much, Mr. Rice.
Thank you, Your Honor.
Mr. Lindsay, are you ready?
Case ready, Your Honor.
Go ahead.
May it please the court and counsel. Good morning, Your Honors. I have to confess that a lot of times I feel like I'm fighting the good fight and banging the drum on a case. And on this one, I actually feel kind of bad about it. I would be much happier if I were telling Mr. Rice that the state would confess error on this case. Because there was an error in the original plea proceeding. Mr. Rice is correct on that point. And Mr. Rice is as deserving an attorney as I know. I wish I could give him good news on that, but I can't do that in good conscience on this case because after reviewing it, the court's without jurisdiction to hear this particular claim at this time. As we discussed in brief and as Mr. Rice discussed, there are only a few circumstances where the defendant can collaterally attack the original proceeding in a motion to adjudicate. And void judgment is the only one that really would, there's the void judgment and, just the void judgment exception. And the four we discussed in our brief are the ones I believe are originally from the Manuel case. It was when the charging instrument doesn't meet requirements, it just fails to charge the crime. When the trial court doesn't have subject matter jurisdiction, when there's no evidence whatsoever to support the conviction, and when the appellant does not have appointed counsel. Now, Mr. Rice, I have to tip the hat right back to him with the Garcia case, because he does bring up another void judgment situation that's been previously recognized by this court and subsequently recognized by other courts, which was the holding in Garcia, saying that an illegal sentence also results in a void judgment, which is correct, and that's a good point. That's in some other cases, it refers to it as the right/parrot exception, meaning that an illegal sentence can also render a conviction or a judgment void. But the problem in this case is that the sentence wasn't illegal in this case. It regarding we were discussing earlier the definition of a void sentence. Well, in Garcia, it does discuss the definition of a void sentence. It's quoting ex parte parrot, which it's a sentence that's outside of the range of punishment authorized by law for something that is either too much or too little, like, for example, a year on a first-degree felony or 25 years on a second-degree felony, something that is not authorized by the law. And that's not what we have here. In the Garcia case, as I believe Justice Trotter pointed out, it was an illegal sentence. He was sentenced to 10 years probated, 10 years on what should have been a state jail felony. It's clearly far outside the range of punishment. On the ex parte Rich case, which Mr. Rice mentions in his brief, a 25-year sentence on a second-degree felony, which is, again, clearly outside the range of punishment. In the Parrott case discussed in Garcia, it was 15 years on what should have been a third-degree felony, again, outside the range. And here, Mr. Schibi received 7 years deferred adjudication on what should have been and what he should have been admonished on was a second-degree felony, which that's not outside the authorized range of punishment, and it's just not an illegal sentence as that term is used in the case law. So what the appellant is complaining of is not actually an illegal sentence. It's a claim of an involuntary plea due to an improper admonition. And the very last thing that Mr. Rice said, I think that's correct, that if he had there, he does have, or he would have had an argument at the time that he could have claimed, I may or may not have accepted that had I been properly admonished on the range of punishment. But the problem is you just can't come back after adjudication and make that argument, because the case law, both from the Court of Criminal Appeals, from this court, from other courts, is that an involuntary plea due to an improper admonishment, it just isn't a void judgment. It's not within the it's not within the definition of what voids a judgment. And the Court of Criminal Appeals expressly held that in the Jordan case, which we discussed. They claim, and they're discussing the Nix case that was issued that same day. They say a judgment is void only in very rare situations, usually due to a lack of jurisdiction. An involuntary plea does not constitute one of those rare situations. And I have to, obviously I haven't reviewed the case that Mr. Rice is discussing, but the way that they discuss no subject matter jurisdiction in the Nix case is something like a official misconduct case where that jurisdiction is solely in the jurisdiction of a county court, a misdemeanor court. A district court has no power to hear that case. And that's just not true of a second degree felony like this. The Jordan case says flatly that an involuntary plea does not meet the definition of a void judgment. And the court in the Patrick case, and again, I apologize, I would have tried to get this to the court a little sooner. I believe I gave it yesterday, but of course the events of the last week made things a little difficult. They discuss in the Patrick versus State case we gave to the court yesterday. They discussed Jordan versus State, and I believe it's Justice Wright saying that in Jordan versus State, the Court of Criminal Appeals held that a defendant who'd originally been placed on deferred adjudication can't challenge the voluntariness of their plea. And that's what an improper admonition is. If you are improperly admonished in the trial court, if you receive no admonishment or you're admonished as to the wrong range of punishment, then you can, at that time, or possibly in a habeas motion, you can say that I was improperly admonished and there was harm. I may or may not have, I didn't understand, I may not have accepted it, if you can establish that. But you can't come back after you've been adjudicated and say, wait, there was a problem way back when I entered my original plea. And in the Jordan case, the defendant that never actually articulates what made their plea involuntary. They don't say whether it was an admonishment, which is why I provided the Hutto versus State case, because the facts are exactly the same. It was an improper admonishment. In the Hutto case, the defendant was admonished on the punishment range for a first-degree felony, and it should have been a second-degree felony. There was just a mistake made in the original proceedings, same as this court. He was sentenced within the range of punishment for a second degree. However, he received 8 years deferred adjudication, again, the same as this court. And that was an involuntary plea that I believe it was the Amarillo Court of Appeals said we couldn't hear. And they mentioned, and it was in dicta because he did not actually make that argument, but they mentioned in passing, said, although the appellant doesn't expressly contend his plea was obtained by the admonishment, now known to have been correct, that he was subject to the subject to the punishment range for a first degree felony. We note that we would have no jurisdiction at this stage of the proceedings to review a contention his original plea was rendered involuntary because of the improper punishment stage admonition. And that's the exact same thing that we have in the instant case, Your Honors. there was an improper admonishment. He was admonished as to the wrong range of punishment. He was told this is a first-degree felony, 5 to 99, but he was sentenced within the correct range. The only difference between this case and the Hutto case is in the Hutto case, he received 8 deferred and Mr. Schibi received 7. It's unfortunate that there was an error in his original proceeding, but the case law just states you just can't come back and make a claim of an involuntary plea in a direct appeal of your adjudication.
Is there
And
any
that's-
any evidence on the record that if Mr. Schibi had been advised of what the correct range of punishment was, 2 to 20, that he would not have pled guilty at the time back in 2013?
That I couldn't tell you one way or the other because we'd have to have evidence on that point, I think. We'd have to have Mr. Schibi, he'd have to testify as to that matter. We'd probably have to hear from his attorney as to whether he was ever told the correct range of punishment. We just don't know. There's just no evidence. But even if that was established, even if it was concrete and crystal clear, he'd have to make that in a writ of habeas corpus to the Court of Criminal Appeals. Because the courts just has no jurisdiction to hear that claim, even if it was correct, which is why I say it's
different setting.
I'm sorry?
Different setting.
It would have to be a different setting. Exactly, Your Honor.
Mr. Lindsay?
I'm sorry, go ahead.
We do know he wasn't charged with a first-degree felony, and the evidence didn't show a first-degree felony, but he's got a conviction that says he was convicted of a first-degree felony.
That
And
is
so with that, my question is this: do you think this court has the power to modify that judgment to reflect?
I've thought about that, and I do not know the answer to that. I don't know if the court, because if you're without jurisdiction to hear the case, I don't know if you have jurisdiction to modify the judgment. I probably would have to put some more research into that if there's even an answer for that. It may be correctable by a nunc pro tunc, or he might have to get an answer from that from the Court of Criminal Appeals. I just don't know the answer to that off the top of my head.
I appreciate your candor.
I would try to put some research into that and see if there's a more clear answer for that. I would hate to mislead the court and tell you one way or the other when I just don't know.
Okay. Anybody else? All right. Thank you, Mr. Lindsay, for your argument. All right. We're going to throw it back to Mr. Rice to give us a rebuttal. You may start when you would like.
Hear me?
Yes.
Thank you. I would first say that it's not just the admonishments that were incorrect here. It's the conviction that's incorrect. As you court noted, he's been convicted of something he wasn't charged with. Again, citing the Nix case, as it says, a void judgment can be attacked at any time. And I take that to mean that it can be attacked at any time, and that's what we're doing here. And I would also just say that if the court, I would say at the bottom line minimum, this court can hang its hat on the Hall case, which says that a trial court has jurisdiction to convict a defendant of an offense not charged in the indictment only when it's a lesser included. This court can hang its hat on that case law, find this judgment to be void, and if a harm analysis is required, this court's decision in Garcia, which says that if the error contributed to the conviction, then harm is established. Clearly, the conviction is a first-degree felony. The error, without doubt, contributed to that. Harm has been established here. This court can hear the case because a void judgment can be heard at any time, and the court can hang its hat on the fact that the trial court did not have jurisdiction to convict him of a first-degree felony when it was not a lesser included of the second degree. all I have.
Mr.
Your
Rice,
Honor.
how would you respond to the question presented to Mr. Lindsay by Chief Justice Bailey as far as whether or not this court has jurisdiction or the ability to reform the judgment to reflect that your client was in fact convicted of a second-degree felony?
Referred to the court's opinion in Garcia, which, if I remember correctly, would just say there's no way that the court can reform this other than to put the parties back where they were. As far as the power to reform it, I'm with Mr. Lindsay. I don't have an answer for that specifically. I would just refer this court to the Garcia opinion, which is basically saying the plea bargain is unenforceable, and the parties just need to be returned where they were and let them renegotiate the agreement. I think if this court just were to reform it to just a second-degree felony, then I think we missed the issue of the negotiations in the plea agreement. It's like we said, had it been properly admonished as a 2 to 20, we don't know what the parties would have negotiated. It could have been something less than what was the ultimate sentence in this case.
Thank you.
Thank you, sir.
Thank you very much, gentlemen. We're nearing the end. What happens is that when we finish here, Ms. Williamson will come on and then recess us, and then we'll go on to conclude the argument. Ms. Williamson.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas